So, hi everybody. I'm Molly Heffernan, Director of Marketing for the Tory Burch Foundation, and this is our small business webinar series. First, I want to extend a really big thank you to our sponsor, Campaign Monitor, a global technology company that makes email marketing possible. They have also been integral into making the small business webinar series come to life, and we are grateful for their support. It allows us to offer this fantastic resource to our community totally for free. So thank you again to Campaign Monitor. Now, today we have a fantastic session about laying the legal foundation for your business. And we have Nicole Pavlik here, who couldn't be a better fit for our community to hear from today. She's practiced for over 10 years in business planning, estate planning, probate work, has a wealth of experience. And I think what will resonate with you all so much is that she also is a small business owner and very familiar with the jargon, the paperwork, all of the behind the scenes, frankly, magic that happens to make running a business possible and successful. So she has helped small business owners lay incredible legal foundations so that they can focus on the good stuff too, the actual idea that you had in the first place, so that you're not in the weeds on dotting I's and crossing T's every single day, and can be, looking at things big picture because you have the right legal in place. So how will today's session work? We are going to have a presentation from Nicole for you all. And after that, we'll have plenty of time for Q&A. So use the Q&A box that you see below to put all your questions for Nicole in there. And we're going to do our very best to answer as many as possible. And then use the chat for all the fun stuff, the shout outs to Nicole, the good energy, all the vibes, the community building. Put that in the chat, questions in the Q&A box. And just a reminder for everybody, later today, this recording will be available to watch playback and watch on our YouTube channel. So if you miss something, it is okay, and you can always go back and rewatch. So with that, you've definitely heard enough from me, and I'm going to pass it to Nicole to bring us through all of this fantastic legal foundation work.
Okay, well, thanks, Molly. I am going to share my screen to get us started. Okay, well, I'm excited to be here today, and with my presentation today, I'm going to be discussing three major things. So I'm going to be discussing legal entities, I'm going to be discussing insurance and contracts, as those are really three major things that are going to help you have a good legal foundation. As Molly mentioned, I am a solo attorney, and I've been practicing for 10 years, and I'm licensed in Arizona, and my business does practice primarily on small business formation and contracts, in addition to estate planning and probate. And this might be a little obvious, but I just have to clarify as an attorney that what I discuss today during my webinar does not create an attorney-client relationship. Anything I discuss is just for information only and is not legal advice. Therefore, I advise you to seek counsel in the state you reside in order to have more specific questions answered after the webinar. The first thing I want to discuss is choosing a legal entity. And I know that a lot of you are probably already established businesses, but I just kind of want to, maybe you were never explained the difference between the different legal entities. So I really just want to have a solid foundation on the legal entities that are available and some general tax concepts that are associated with them. Understanding that when you choose a legal entity, there's a legal side to things and a tax side to things. And that's why I always recommend that my clients reach out to a tax professional in order to determine what is going to be the best for them. What is a tax professional? Well, a tax professional could be a CPA, it could be an accountant, it could be an enrolled agent. It's really up to you or my clients in that matter to choose who they want to consult for tax advice. I would prefer to get the blessing of a tax professional on what entity is the most appropriate for my client before starting the legal side of things. But obviously, if that's not the case, I would move forward regardless and in hopes that they would eventually seek out a tax professional. If you already are an established business owner, no matter where you are in the process, it is always good to have a tax professional in your life and to, make certain that you are using the appropriate legal entity for your business and structure. Today, I am going to be talking about 3 different entities, and I am going to be talking about some tax-related things to each entity. But as I am not a tax professional, it's just general information and understand, again, just to consult the tax professional in regards to more specifics. The 3 entities I'm going to be discussing are sole proprietorships and partnerships, which fall under the same category, limited liability companies, and corporations. What I will not be discussing today are limited partnerships and limited liability partnerships, only because those aren't as widely used, and I really just wanted to kind of focus on the main entities that I see most commonly being used in today's industry. The first are sole proprietorships, partnerships. So sole proprietorship is pretty obvious. It's one person. Then a partnership is just, as long as it's more than one person, you have a partnership, but they fall into the same category. Typically, there's little or no cost to establish a sole proprietor partnership because you can just start doing business as one, and therefore they're informal. However, at least in Arizona, so again, research your own state, but if somebody wanted to operate under a business name, that there would have to be some paperwork filed with a state organization. In Arizona, if Mary Smith wanted to operate as Mary Smith's Crafts, then she's going to have to file some paperwork with the state in order to do so, and still just minimal cost in order to do that. All income that is generated by a sole proprietorship or partnership is then reported on a personal tax return. Liability protection is going to be something, or personal liability protection or liability protection is something that I'm going to mention quite frequently through this webinar. So I just want to establish what I mean by that. So personal liability protection is when your personal assets are protected from the debts or lawsuits of a business. So they are separate and apart, and they cannot, your personal assets cannot be up for grabs, you could say, if the business is sued. A sole proprietorship partnership does not provide personal liability protection for its owners. Next is a limited liability company. And typically they are easy to set up with the Secretary of State in your state. Ironically enough, in Arizona, you don't establish an LLC with the Secretary of State, you establish it with the Corporation Commission. So even though I say Secretary of State, again, it might be different in your particular state. When you are establishing an LLC, you are filing initial documents to organize it, which are called articles of organization. And they might, the term might differ a little bit between state to state, but relatively similar to that. The articles of organization are going to establish certain things like the name of the LLC, who the registered or statutory agent is, who the members are, addresses, things of that nature. A lot of this is moving to online, and it seems to be relatively straightforward in a way to set it up. I would find that most people are able to establish that initial articles online themselves, but if anybody would ever feel uncomfortable doing it, I always advise seeking an attorney to advise and help as much as needed. An LLC cannot be publicly traded. An LLC does provide its members liability, personal liability protection from business debts and claims. So unlike the sole proprietorship or the partnership where there is no liability protection, obviously in the name of the LLC, there's liability in it. There is the liability protection for the members of an LLC. Lastly, with an LLC can be managed by members or managers. So just really quick, just a little education. Members are the owners of an LLC, and the managers, you can say, are the people or person who manages or runs the LLC on a daily basis. So there can be a member managed LLC, which means that the members, the owners, are also managing it. So they run the business, they own it and they run it. There could also be what is called a manager managed LLC, and that just means that there are members who own it, and there could be one or multiple people who manage it who are not members. So by the name, it's a manager managed LLC. And then there can kind of be an overlap where there are members who also manage the LLC, and they would be called a managing member. But in addition, there might be another member who doesn't have any management power. So essentially, there's different ways that you can set up the structure of an LLC, and just understanding and being able to consult an attorney and a tax professional about the structure when you go to do that. Corporations. So corporations, like LLCs, you are going to file initial document called Articles of Incorporation. They capture similar information to Articles of Organization that were for LLCs. They're going to capture like the name of the corporation, the shares that are issued, the directors, the shareholders, addresses, things like that. The corporation does have more legal formalities in the sense that there are usually annual minutes that should be kept in the corporate books, and which detail and outline when directors or shareholders have meetings. And again, just a little education is that a corporation is managed by directors chosen by shareholders. So shareholders are the owners, just like the members of an LLC, and the directors manage the corporation just like the managers do to an LLC. A corporation is preferred for investors because they would have a stake in the company in the form of shares. And of course, a corporation is going to provide personal liability protection for its shareholders, just like an LLC does for its members. Liability protection is not available for personal guarantees. This is, so again, the liability protection is involving whether there can be a claim or lawsuit against and bringing your personal assets into the mix, even though they're coming after the business. Personal guarantees are essentially a personal promise, either, to be responsible for a lease or, a debt. Unfortunately, when you sign a personal guarantee, you are putting yourself personally on the hook for that. And a lot of times it's unavoidable because, a bank or a landlord isn't going to take the risk that the business could fail and they don't have any recourse because the business doesn't have anything. So they know that they want to protect themselves by making that the business owner personally responsible for it if that should happen. So it does allow them to bring in personal assets at that point in time. And like I said, unfortunately, sometimes there just isn't an option, but I just wanted you to understand that even though you might have an LLC or corporation, it isn't always going to protect you. And this is one situation where it wouldn't. There are two different types of corporations. There is a C corporation, and that is standard. So if you were to file your articles of incorporation with your state organization, you are automatically a C corporation. A C corporation has what is called double taxation. And what that means is that the corporation is taxed, and then after it's taxed, then the shareholders are taxed on what they are distributed. There is also an S corporation. An S corporation is just a tax election. So you actually, or tax classification, sorry. So you actually have to make an election with the IRS to be an S corporation. And you would do that with a form 2553. There are deadlines to make that election, but you can actually explain to the IRS why you're tardy with that election. I would recommend you search out or reach out to a tax professional with help with that process, just so the IRS doesn't deny your reasoning potentially. The S corporation has 100 or fewer shareholders, and maybe that's totally not an issue for most people, but just so you know that is a requirement. And another requirement of an S corporation is that all the shareholders have to be US citizens. The S corporation is taxed once at the shareholder level. So just a reminder, the C corporation is taxed at the corporate level, the corporation itself is taxed, and then the shareholders are taxed for what they receive. And then the S corporation is only taxed, the shareholders are only taxed. However, the shareholders are taxed on all profits of the corporation, meaning just like a sole proprietorship or partnership where all income flows to their personal tax return, that is what's happening with an S corp. All income is reported on the shareholder's personal tax return. Unlike the C corporation, where the shareholders were only being taxed on what was distributed to them. So if there were assets being held in the corporation, they wouldn't be taxed on that. But the S corporation doesn't matter if the shareholders, leaves money in the corporation or distributes money out, they're taxed on everything. So that is a big difference between the two of those. The great thing I think about an LLC is that it can be taxed as any of these entities. And again, in my opinion, for most people, it is my preferred go-to as an LLC because of the options that a client's going to have. And a lot of times it's the growth of their business that allows them to then adjust how their tax classification. So they could start off and then, in one way, and they can, as they grow, it could make sense to be taxed at a different classification. Understanding that there is no such thing as being taxed as an LLC. Once you file the articles of organization with your state organization, you are automatically either a sole proprietorship or partnership. And from there, you would need to, if you didn't want to be taxed in that way, then you would have to make the election. As I mentioned on the previous slide, if you want to be taxed as an S corp, then you would need to file a form 2553. And then if you wanted to be taxed as a C corp, then you would file a form 8831. I do have a lot of clients that mention that they are an S corp when I ask about their entity, and a lot of times, and it's just they're not understanding, but then I ask, are you a corporation or you're an LLC? And they just continue to say they're an S corp, understanding that there's no such thing as an S corp. So either you are a corporation choosing to be taxed as an S corp, or you're an LLC choosing to be taxed as an S corp. So it is always good just to understand your actual true entity and how you're choosing to be taxed. Operating agreement and bylaws. So these are, we're now moving into like agreements, but these are like internal agreements in the entities themselves. So an operating agreement is traditionally what is used for an LLC, and bylaws are the internal agreement for corporations. And these agreements govern the internal operation of LLCs in corporations. These documents are not filed with the state. So articles of organization and incorporation are, but these, like I said, since they're internal, they are not filed anywhere. They are just establishing how the businesses are essentially going to run. So some of the things that the operating agreement would outline are like how voting happens, what's considered a majority, when are meetings, how are disputes settled, how are directors, when are directors meetings, shareholders meetings, things like that. What I say should be included in operating agreements and bylaws are a roadmap for when unexpected things happen, such as the death, incapacitation, or divorce of either a member or shareholder. And I say should include because traditionally operating agreements and bylaws do not include this language. This is what's considered buy-sell language, or it's what's usually found in a buy-sell agreement. What I'm seeing is a trend to include this type of buy-sell agreement language automatically in operating agreements and bylaws, which I think is how it should be. I do not think they should be separate agreements. I think that all businesses should have this type of language in their operating agreements and bylaws. So again, fingers crossed that it's slowly moving that way to become the standard, but in the meantime, we have to address it. That means if you currently have operating agreement and bylaws, what you need to do is you need to look at them and see if there is this type of buy-sell agreement language in there. And if there's not, then you need to do one of two things. You need to either just choose to have a separate agreement, a buy-sell agreement prepared, establishing this type of information, or you can amend your operating agreement or amend your bylaws to incorporate it in there. And then of course, if you don't have these already in place, then you know that when you go to establish these agreements, that this is the type of language that needs to be in here. Why this language is so important is because I say that it's like a prenup language for a business. It's the things that typically cause fights between shareholders and members or their family members. So we want to address it before that even becomes an issue, or like how are you going to handle those things when they come up. An example that I can give so you understand exactly why this is important is I'm going to not even talk about like death or incapacitation, but let's just say that there's an LLC and there's two members and they own 50-50 and they've been, they have an operating agreement, but it doesn't have this language in here. And then maybe one day one's just like, I'm totally over, Bill, I want out. I don't want to do this anymore. And so he goes to Bill and says, hey, I want out. Like I own 50%. You're going to have to buy me out. Then what happens? So what they haven't established is how is the, obviously the departing member, his interest has a value to it. How is that going to be established? So obviously they need to establish the value of the business itself. How is that going to be determined? Are they going to use like a formal business valuation? Are they going to use some sort of formula based off the revenue of the business over a period of time? And even once they establish that, what if the LLC or the or the actual the members that's not leaving can't afford to pay out the departing member? What if they don't have enough like liquid cash to pay them out? Well, then it's probably going to have to be paid over a period of time, and then a promissory note is going to need to be prepared. But what's the terms of the promissory note. What interest rate are they going to use? What is going to be the term of the promissory note? So you can see how important this information is. Like if you establish it to begin with, then it's going to avoid there being a lot of fighting and disagreement when things are already not good. Like obviously if a member wants to leave, then it's most likely not on great terms. So if you have that established beforehand, then you just know the process. And that same idea applies if a member passed away, then that member's family is going to have to go through the same steps that even a departing member would, dealing with the other member, like pay us up. How is that going to look like? Are you going to pay it over time? And then there's also insurance available, like key man insurance, where you can get an insurance policy for the owners of a business. So if one person dies, in order to pay the family members or to be able to to pay that ownership percentage instead of having to come out of pocket or the business to come out of pocket, that insurance would make up for it. So you can probably see and understand why this is so important to have in your agreement. So again, buy-sell agreement is typically what it was called. Look for that language, otherwise address it either by incorporating it or adding on a buy-sell agreement to your current operating agreement or bylaws. Okay, so there is, in addition to the personal guarantee that I mentioned earlier, there is no personal liability protection when, and then there's two times that there's no personal liability protection for the business. The first is if the corporate veil is pierced, and even though it's a corporate veil, it does apply to LLCs as well. And what that means is that there is no discernible difference between the entity and the members. It's so commingled that there's no separate identity. Meaning that like there is the owner and the business, like they're essentially operating most of their business out of their personal. There's maybe no assets in the actual business. Maybe they don't have an operating agreement or bylaws. Maybe they're not even filing taxes. Just lacking the corporate formalities. They're undercapitalized. Like I said, they don't have any money in the business. They're really it's just kind of like a shell. Well, you can't just have a shell and then think that it's going to provide you protection if the business does, has a claim against it. The argument is like, no, if you haven't used this entity correctly, you don't get to hide behind it, and they can pierce it and come after personal assets. The second time when there is no personal liability protection is when there is negligence or malpractice on your part. And this is huge. This is the biggest misunderstanding that I can say that business owners have on how the liability protection of an LLC or corporation works. Is they think that at all times the entity is going to protect them, but it does not protect you against something you do wrong. And this is why you need to have insurance. I'm not an insurance agent, but I do understand the importance of insurance and why it is needed in combination of having your entities established. So malpractice insurance, I have malpractice insurance. So if I mess up, my LLC is not protecting me. They are coming after me, but I'm going to have insurance to protect me from them coming after me personally. Malpractice insurance usually applies to certain professions, so lawyers and doctors and others, but there's also what's called errors and omissions insurance, or E&O insurance, and that really it just covers like a variety of different professions that are out there. And ultimately what that is going to protect against things like, again, like incorrect advice, failing to deliver services on time, any mistakes you make. So this is not an exhaustive list, but it's just an example of what it's covering. And really you need this type of insurance if you are in a business where you're providing services to a client for a fee. And then it is going to cover the business owner and typically the employees. I always say that if you are working or you're contracting, work out to an independent contractor, it's always smart to make sure that they just have their own insurance. So everybody's covered at all times. What malpractice insurance or E&O insurance is not going to cover is inherently bad actions. Like, it's not good if you're doing something like fraudulent or illegal, or you're doing false advertisement, it's not going to protect you. You shouldn't be able to have insurance protect you from being bad. It seems pretty obvious, but obviously it's just making sure you understand that it's covering you for, oops, like I messed up, but not that you were intentionally doing something wrong. The additional type of insurance that's out there, I'm not really going to get into a whole bunch just because, but there is just like general like liability insurance that businesses have, like third-party bodily injury or third-party property damage. And this is like the type that typically, like if you have a lease, they're going to require a certain level of coverage on these things. And then there is like data breach and cyber attack insurance that's even like a separate policy than this, that's becoming more popular, that people probably should look into just because that is becoming a popular concern for people. But obviously you just want to make sure to reach out to your insurance agent and discuss these things. Okay, so contracts with your clients. So assuming you are providing services to your client, you would want to have a contract with your client in order to establish the services you're providing and all of that stuff. I say short is not better, so don't cut corners. And that really just means that you want to cover yourself with a contract, and by limiting the length of a contract, you could potentially be jeopardizing yourself to certain actions because you just wanted your contract short. So for example, I've had people come to me and say, hey, Nicole, I really want a 2-page contract. I tell them, I will not prepare a contract based on length. I will prepare a contract based off of your services and how you need to be protected. And typically the reason is what they want a short contract is because they feel that if they give their client a contract that is too long, that client will say, oh, I'm intimidated by this contract and I don't want to use their services. And I mean, at the end of the day, if that's how their client is going to be, then I think that they actually lucked out, because they shouldn't want to work with somebody who doesn't want to read maybe a 4-page contract or 5-page contract. That's silliness. So, and that's really because contracts really, and at the end of the day, they really are protecting both parties, even though the idea for most people is that they're trying to protect themselves, but they're still protecting both parties. A contract is a visual representation of the relationship. It's saying, this is the services we're agreeing to. This is how you're going to pay me. This is when you're going to pay me. This is what's going to happen if, you don't pay me on time. So it is protecting both parties. Therefore, it will prevent conflicts. I didn't say eliminate conflicts, but prevent conflicts. But there should be in your contract a way to handle disagreements. So if there is a conflict, how is that addressed? Hopefully, usually through some sort of mediation or arbitration. Therefore, it should give security and peace of mind to all parties involved in the contract. Scope of work is really the thing that I focus on with my clients in ensuring that they are covering themselves. So scope of work is outlining exactly what they're going to do for their client. Even though I don't prepare this section a lot of times for my client, because they know what they're doing, they know their industry, they're able to eloquently say what they're going to, what services they're providing. I might review it, I might have recommendations, but what I do tell my clients is you have to be specific and don't assume anything. Don't assume they know what you're going to do, and don't assume that they know what you're not doing for them. And I know it seems weird to incorporate things you're not doing for a client, but maybe it's part of your industry standard to do certain things and you don't for whatever reason. Like I don't litigate. So I have to clarify to my clients, if litigation comes up, I'm not your girl and you will have to seek other counsel. So there doesn't hurt to clarify that. And additionally, if services change, you want to update the contract. You know, if you go through the process of having a contract and then you start doing verbal changes, you're kind of unraveling everything you've just done. So make sure that you update the contract. I do have clients that have previously, before seeking my services, used to, instead of having verbal changes, that they would email their clients back and forth and say, like, this is what I'm going to do for you now. I don't hate that idea, but if you can foresee yourself doing that, then again, in your original contract, I suggest that you just say, any future changes that we do will be done via email, and this is the process. So then you know that you have a process for one, and that two, that email will then be incorporated into the original contract and fall under all of the other terms. So you're covering yourself. Lastly, what I tell my clients is don't use ambiguous language. And the biggest ambiguous term is reasonable. What's reasonable to me might not be reasonable to you. And it's usually used as reasonable amount of time. No, avoid that. Avoid. You need to be as specific as possible without using reasonable. Other provisions that are typically in contracts with your clients is going to be like a timeline of services, compensation, termination, and dispute resolution. And just really quickly with termination, you can have a termination clause that's like kind of a termination for convenience. And that just means that maybe there's not a breach in the contract by either you or your client, but you're just like, I don't really want to work with this person anymore, whatever comes up. So you could basically say that the contract can be terminated without cause, which means that there's no reason, but typically you would give the other party, a certain amount of time notice. So you just can't say, hey, I don't want to work with you anymore, the contract's over. You could say that, but you would have to provide a certain period of time notice in the contract, 30 days, 60 days, 90 days, whatever that looks like. But without that termination for convenience clause, you really just can't arbitrarily terminate the contract. But these are relatively common terms used in an agreement. So you should look to that and make sure that you have a relatively reasonable amount of time for termination if you do have a contract. And then dispute resolution would just be, like I said earlier, deciding about mediation or arbitration if disputes come up. The miscellaneous or general provisions at the end of the contract, boilerplate, people end up thinking that they don't need them, they cut them out, they don't think they're important because they're boilerplate, but actually they're boilerplate for a reason. They should be in all contracts. Whether they vary or not is a different story, but ultimately these are just such important things to be in a contract that cutting them out is actually doing you a disservice. Some of them, and just include, these are just really quick examples, assignment, whether you can assign the contract or the rights and obligations of a contract to a third party. So you can decide if you agree to that or not. The entire agreement is another provision, and that just is saying that the contract you are signing, the two of you are signing, or the parties are signing, is the entire agreement. Anything else outside of that up to that time is not included. Acts of God. So this is typically called the force majeure clause, and that would be acts natural disasters, floods, things that are going to, unforeseeable, or going to potentially prevent somebody from being able to fulfill their contract just because of impossibility or impracticality. Pandemic is now starting to be added to these provisions, which is fine. courts are kind of in undecided about how to determine if previously prepared contracts with acts of God that did include pandemic should include pandemic, but that's a whole other story. Just understand that if you do have a contract, you may want to add pandemic to your acts of God. But the biggest thing you need to with acts of God, regardless of what you consider acts of God, is that you need to outline what breaches are excluded or included. So example for a lease, they could say what is excused is, what is not excused is payment of the rent. So they can say like acts of God could happen, but at all times your rent is due when it's due. So that's just an example. No waiver is really important because what it's essentially saying is that you have a right to enforce a provision that you may have previously been relaxed on. So let's just say that you have a client, you have a policy that if a client is late if they don't pay your invoice within 5 days, there's a late fee. And let's just say the client has been late twice and you've done nothing. And then on the third time you say, hey, you're late, so pay me the late fee. They can't come to you and say, well, you didn't enforce this provision previously, so I just thought you weren't going to ever enforce it and I shouldn't have to pay the late fee. And then you can point to the no waiver provision and say, no, I can be relaxed when I want to, and I can enforce this now because I want to. So that is super important. And then lastly, governing law and venue for lawsuits is going to be important, especially, it seems pretty obvious, like, oh, this is the governing law of the document, is California, Arizona, whatever. But you, especially if your client is in another state, you are establishing that you're gonna operate under the state that you're in. Obviously, I am impartial, but contracts should be prepared and reviewed by an attorney. I've had plenty of clients who've been utilizing a contract. Maybe they pulled offline and they're like, Nicole, I'm growing. I want to make sure I'm covered. So I'll review it and we'll tweak it. Maybe I tweak more provisions in one client than another, but I think that it's really important that you have an attorney look at them and to ensure that you, like I said, are protected. And then of course that, if possible, have an attorney prepare the contract from the beginning if you don't already have a contract in place. And then lastly, if you're going to go hire an attorney, these are just things, you could look out for is what are their typical clients? Like if you're a small business, you probably don't want an attorney that's used to working with, a business who has like 1,000 employees. You want to know what their experience or practice area is. Like, I'm not saying that your friend who's a divorce attorney can't review a contract, but since that's not really their primary focus, they might miss something that should be in the contract because they're just not used to reading business contracts. How do they bill? Do they bill hourly or flat fee? Flat fee billing is becoming more common. So you would know exactly how much you are going to spend on that, like contract preparation or review if they are doing a flat fee billing. Turnaround time, obviously you need to know if the attorney is going to be able to prepare, review the contract in a reasonable amount of time, if they're going to be able to explain things at the right level, if they're going to continue to speak in legalese, or if they're going to break things down for you and explain things, on a more basic level. And of course, if they're business owners themselves, they're going to be more relatable. Not to say that an associate attorney can't review a contract or prepare a contract, but you're obviously going to relate more to an attorney who owns the firm or is a partner of the firm. Okay, and then I am done with that.
Well, Nicole, this has been great, and we have a ton of questions. So I'm just going to dive right in. A lot of people on today's call are consultants, and it's them. They're the business. So a question that came in is, should I be setting up an LLC or billing as an individual? Like, what are the pros and cons of doing that risks? I think you were covering it before, but I want to answer this directly because I think a lot of people have this debate for themselves.
Right. So, I mean, I guess going back to like the original, like it's, and I do have a lot of clients who are in the same position and they have, I think that it makes sense to operate as an LLC only because of the fact that there really isn't a downfall. If they're going to operate as a sole person, they can operate as an LLC as a sole person, and they still at least have a little bit more liability protection with the LLC. And there isn't going to be a ton of paperwork involved with an LLC, and everything is going to fall to their personal tax return anyway. So I don't really think there's a lot of work involved if they just want to go that direction of establishing LLC going forward.
And I think that dovetails to another question that came in. When you're then going to purchase, insurance, should you be purchasing for the LLC or for yourself as an individual when it's just you?
Yes, so it will be you. I mean, they'll probably want information on the business, but it is going to be covering you personally. Yes.
Great. All right. These are going to bounce all over the place,
Yeah.
but bear with me. All great questions. So a lot of entrepreneurs set up an LLC, but then there's a doing business as. Why? What are the pros and cons? Like, does it matter?
Yeah, so the LLC, like doing business as, so it could be just a few things. Like, I've had clients who've set up an LLC and maybe they just set it up as their name. And so, or they set it up as their name, but they want to actually do business as like something else. So they, instead of changing the LLC name, or maybe they want to have variations of that name, like they could, like, in Arizona, like they could say like, I want ABC Phoenix, ABC Tucson. So they could like have offshoots of like the same name. So it gives them just more of a variety, but the LLC is ultimately like their original business name, but like what they would put on business cards or letterhead would be what they're doing business as. So you can do both. That doesn't prevent you just because you're an LLC, you could also do a DBA.
I think what you just said dovetails well into MJ's question, which is MJ has an LLC in Florida, moved to Arizona. So would MJ or any entrepreneur moving from state to state with their business need to dissolve in one state, start in another? Like, is the process starting all over if you're essentially moving yourself one place to another?
Yes. So if they're actually not doing any more business in the previous state, like in Florida, then they would dissolve the LLC in Florida and establish it, but they wouldn't have to do anything like with the IRS other than updating their address. Like, it's not like they have to do anything different after that. Mm-hmm. However, I do have clients who are still doing business in Florida and Arizona. So in either of those states, so you would have to establish what's called a foreign LLC or foreign corporation. So that just means there is the state where the LLC was established, and now you are now doing business in other states, and that would be considered a foreign LLC. So you could operate in multiple states, but you're having to establish an LLC in multiple states because you're going to be doing business there.
Great. This is a bit of a deviation, but a few people asked about trademarking, patenting, protecting their work. So are there certain types of contracts, considerations, or filings that entrepreneurs who are maybe like Shmare in the chat here, who has a bag design that might be worth protecting, like many other people in what they do as signature? Like, what should people be sort of considering, or questions they should be asking themselves when it comes to that sort of proprietary information?
Right. So that is, that's like intellectual property. So there's like intellectual property, patent attorneys who focus on that. Like, understanding that like you could have like when you have a name of a business and you file that with the state, like you're protecting that name. But if you have a logo or something, like you would have to file separate paperwork on a state level. But if you're wanting to protect an idea like that, or you want to protect it nationally, then you're going to have to file it with the United States Patent and Trademark Office. And absolutely under no circumstances should you try to do it yourself, because the process takes forever and they will reject people who try to do it themselves. So if you need to use an attorney for that in order, but I think that it is like with that example that you gave, I think that that makes sense on something too that would go through that process and is worth going through that process.
Mm-hmm. Yeah. It's certainly something we experience all the time at Tory around product and things like that. So definitely great advice. A question came in, and it's, I think, similar to the independent contractor question around, should I operate my business solely online? Should I register as an LLC or a corporation? Like I'm online, you know, are there reasons to protect that kind of business?
I mean, at the end of the day, like the idea behind either the LLC or corporation is that if you have that you are ultimately wanting to kind of separate yourself from the business. So if something happens in the business other than something you personally do, again, then the business is going to protect your personal assets. So at the end of the day, you know, again, this is not my legal advice, but it makes sense to set up either an LLC or corporation for that reason, just to have that peace of mind that if something does come up, even if it's just online, that you are protected from them suing your personal assets.
A follow-up question from Angela on LLCs is, and we see a lot of Delaware LLCs. Is there a benefit to establishing as a Delaware LLC, regardless of where you're located? And then just naming in the state that your business resides? Like, what should people do?
So there used to be, like, Delaware was the first state that established LLCs. So for a long time, there wasn't LLCs in other states, or there wasn't really statutes regarding LLCs. Well, I mean, that has changed so much. So the idea behind like Delaware providing like a benefit over filing in the state, I mean, because regardless, if you set it up in Delaware, you're going to have to set it up in the state that you live in or operating in regardless. So and Delaware LLC has a totally like phased out. I still think it's floating out there, but essentially it's not really doing much of anything.
A lot of entrepreneurs on this call have like a purpose component to what they do. If they eventually want to register as a B Corp, is there a certain entity that you recommend or that they should consider starting out as?
So, I mean, I guess in that situation, it would make sense to set up initially as a corporation. Yeah. If they're going to eventually go that direction. Yeah.
Great. And now a few people asked, what is the process if I need to switch? How I've set my company up? What are some of the, or my business up? If I want to switch from an LLC or something else, what are kind of those first steps?
So there are statutes in each state. It's funny you say this because I just have a client who was a corporation and now he just wants to be an LLC. And each state has like a way to make that, like a lot of states have statutes that's called like, it's just kind of like a merger of the two, and it's very straightforward and there's not like a really whole lot that needs to be done. And Arizona doesn't have such an easy process, but essentially there is a way to convert. And then there is going to be a second component with finding out with what you're going to need to do with the IRS, because a lot of like with LLCs and corporations, I'm sure those of you have it, you have a tax or employee identification number. And sometimes depending on when you go from one entity to another, you might need to get a new employer identification number. And then there's times that you don't. So you would just need to check with the IRS on that. But on the state level, there's just going to usually just be some straightforward paperwork that you're going to fill out that will allow you to go from one to the other.
Great. Okay, I'm going to jam through like 2 more questions. Joanne dropped in the chat, what are your thoughts on NDAs and when should entrepreneurs be using them?
I do think they're important, and it's something that obviously I didn't mention, during this webinar specifically, but I think that not that I do it right, but I just like kind of automatically either I include that language in a lot of times with my clients, like agreements, just to make it clear on the things that, typically they have things that they don't want to be disclosed to other parties. So it is kind of built in. But I mean, honestly, I think that, in most situations, they're in your agreement with your contract, or they're a separate, you can prepare it separately if it's not already in there. But I really just think they should be used all the time, just because you do want to just protect like any proprietary information that you have.
Great. All right. I think I'm going to get one more in. If somebody has a nonprofit organization but wants to set up an LLC in order to do, or set up a for-profit in order to do sales under the same name, is that okay? I guess.
Okay. So I guess that's like, it depends. Like I guess it depends on like if they're no longer going to use that nonprofit and they're moving to they're just moving to an LLC, then they probably are, because that name, they'll no longer have the name as a nonprofit, they'll have it as an LLC. But if they're wanting to keep the nonprofit alive, then they're most likely not going to be able to use the same name. Usually the states don't like that, even if they're the same parties were involved. They don't like the confusion. They want the name to be at least a little different.
Great. All right. Well, I mean, there are endless questions here, and I think we could truly go on all day, but I want to be conscious of your time. And I know our whole community is so grateful for your expertise. You have a lot of shout outs in the chat, best session, such critical information. So Nicole, thank you so much for just walking us through all of these considerations. I think one big takeaway, everyone should have an attorney, a tax professional, and really be putting this at the forefront of setting up their business. Any other parting advice for everybody when it comes to this?
No, I think you actually summed that up perfectly. Yeah.
Well, thank you again. And entrepreneurs who are